Before the meeting commences, I would like to acknowledge that we are meeting on the land of the Bidjigal and Gadigal people who occupied the Sydney coast before being the traditional owners. On behalf of Randwick Local Planning Panel, I acknowledge and pay my respects to the elders past and present. Good afternoon and welcome to the Randwick Local Planning Panel, which is convened to consider Development Application 138 of 2019 for 190 to 192 Oberon Street, Coogee. This application was deferred by the panel at its meeting on the 14th of November 2019. I'm the chair of the panel and my name is Annalise Tour. With me are Oliver Klein as expert member and Michelle Finnegan as the community representative on the panel. Sandra Robinson, who was an expert member of the panel on the 14th of November, is no longer a member of the Randwick Local Planning Panel. Prior to the commencement of this meeting, all panel members were required to sign a declaration of interest in relation to each matter on the agenda. I can confirm that all declarations of interest have been received and that no conflicts were identified. The signed declarations of interest will be available to view through Council's website by tomorrow afternoon. Today we have a representative of the objector registered to address the panel, and the applicant is available to answer questions. Each speaker will be given 3 minutes to address the panel. The panel has been provided with copies of all the submissions received in response to the public exhibition of the application. Therefore, there is no need to repeat all the points made in those submissions, but rather to focus on the key matters that you wish the panel to understand and consider, including any suggestions about how concerns could be resolved. So I'll ask Mr. Tony Moody on behalf of objectors to come forward and speak.
Chair and panel members, local residents. My name is Tony Moody, I'm a consultant planner. I appeared at the previous meeting of the Randwick Local Planning Panel. You will recall that the issues of green corridor and the visual impact from the southern properties were of fundamental issues of concern to my clients. Listening to the audio recording and being personally in attendance at the meeting, I gained the impression that the RLPP, the Randwick Local Planning Panel, was not favourable to the original proposal, but after the applicant sought a deferment, the panel, quite correctly in my view, gave indulgence to deferment to try and address the concerns. Panel members, you gave very clear parameters as to what should be included in an amended proposal to satisfy your concerns. One of those clear parameters was a 3-storey appearance from the southern properties. It is acknowledged by William Jones, honestly so, at page 5 that, quote, the amended proposal will have a 3-storey appearance when viewed from parts of southern properties, but likely that the development will read as 4 stories from other parts. Why is this so to speak? The reason for this is that the applicant's photo montage from 262 adopted a location on the rear or close to the rear deck of 262. The applicant's architect clearly considered that was an appropriate position to view the photo montage. We entirely agreed. And position B is there. However, the applicant's architects in the most recent proposal, as evidenced by the sightlines, has put the viewing location adjacent to the southern boundary, very close to the sheds. In other words, they have pushed the location, the viewing point, very close to the southern boundary. At that point, you will only see a 3-storey development. From a point closest to the main recreation areas of my client's property, you will see a 4-storey development. Part 3, part 4-storey development. I consider that that viewing location is inaccurate and flawed and inconsistent with the applicant's own photo montage as part of the original proposal. The planning panel gave clear parameters. We seek rejection of the proposed development. It has not, the amended proposal has not followed your clear parameters. If, however, you are of a mind to consider amendments, as is my duty to the panel to advise, we would ask that adopting the comments of Chair Tour to actually move the rear building to the back of the front building. So you move it in area A, you push it to the front. May I have the indulgence of an extra minute, Chair? Thank you. You push the rear building to the front, and that was a very concept that was mentioned by Chairperson Tour in the previous meeting. That will achieve the 3-storey appearance from the rear properties. Any loss of floor space, and I consider it to be minor, can be built or replaced in the building location zone. That the rear building is significantly set back from the front building line. So you can actually compensate the developer for any loss in area A by allowing additional building bulk in the BLZ. Chair and panel members, my clients greatly appreciate the serious consideration you've given to this matter. It is a very important matter. It has potential impacts, grave impacts on my client's amenity. We are merely seeking to have an amended set of plans which reflect the parameters adopted by the panel. Thank you very much.
Any questions? Mr. Moody, do you have any comments on the revised clause 4.6?
I think it's flawed. I think it's flawed because rather than having positive environmental grounds, I consider that it creates the very adverse impacts highlighted by the RLPP at its previous meeting. Obviously, the amenity impacts for the future occupants of this proposed development will be positive, but to the detriment of my client's amenity. Thank you.
I think we do have some questions of the applicant's representative, so, because you're not registered to speak, are you?
Sorry about that. I thought it was registered.
So you thought you were?
Yeah.
Okay,
I did have something just to present.
Yes, we'll allow you to speak.
Thank you. Just got a stick to go in there. Sorry, I'm not sure for it. Okay, it'll be right. Just open it. Is that legible to you? I can blow it up a bit more if you like. Is that all right? Thank you, panel, for the opportunity to speak again this afternoon, and also for the opportunity for the deferral. In our opinion, we believe we have addressed each of the 4 items that were listed at the last panel meeting. I'd have to dispute what the earlier comments are from Mr. Moody. The concept of a building location zone is in fact actually met by this application. There are side setbacks and rear setbacks. We're actually set back further, as indicated by the yellow vertical column. That's the rear setback line. We're actually set back further than required. So we're within what's required by the DCP, beyond the DCP, and we're also beyond the ADG, where you've got to do the 6 metres plus another 3 metre transition zone to the R2 zone. So not only are we back further, but the upper level's also set in from the sides as well. So the top storey hasn't just been set back from the rear, to a substantial extent. As you can see, it's 15 metres rather than 9, but it's also been set in 2 metres on each side. So that built form, when viewed from a very large distance and with significant existing trees and proposed trees, will be a very modest element in anyone's line of sight. Why there was 2 lines done? Because it shows actually where the relevant aspects were on the neighbouring properties. Yeah, the further you go back, of course you're going to see something that's set back, but when we're talking about a distance of 30 to 40 metres, that's a substantial area. So they will see it, but albeit from a significantly larger distance than one would typically assume for a building in this zone. The L-shaped design has been very much endorsed by the Design Review Panel. What that provides for is a north-facing communal zone, whilst also being able to achieve a buffer to the south, which is beyond that required. So I don't think there can be any criticism of the proposed design or that this site is benefiting at the expense of any neighbouring property. In fact, we're set back so much further than the neighbours than required. There's also a double-sided arrow there which shows you the height where the built form is, and that's a 9.5 metre height. So that what it is showing in the foreground is 3 stories, and then there's a planter box with planting in it. So once that planting grows, you'll actually see very little of that upper level, considering it's also set back from 3 sides from their perspective. So I think Mr. Jones was quite correct in his report that of course you will see something the further back you are, or from the first floor of that property. But given the extreme distance of separation, established screening and proposed additional tree planting, which was another point that you requested to be addressed, which has been done in the rear setback of this property. So it's agreed there's no shadow impact. There can be no visual privacy impact. Yes, please, just 1 minute. Yep. There can be no visual privacy impact. There's no view impact. It's very much a visual buffer only. Now, taking into consideration all those aspects of deep soil planting, extreme distances of separation, particularly in a dense suburb such as Coogee, I don't think there can be any criticism of the proposed built form. Happy to answer any questions in response to last meeting.
Any questions?
A couple. The landscaping at the ground level or the lower ground level to the rear, is that private open space? The one that flanks the
Yeah, it is.
the perimeter.
Yeah.
So each unit, units LG01 and LG02
Correct.
will have additional private open space.
Yep.
Okay.
And there can be conditions to that if that needs to be maintained by a communal, like by a caretaker, I suppose, if there was a concern in that regard.
In the circumstance of approving this application, condition 2 or condition 2A through to 2L, are there any particular issues with the way that's been drafted or worded?
Yes, there are. I'll just go to those. Particularly the one along the, I'll just get to the actual number, sorry. We did have an issue with B, and those balconies are off bedrooms, and we felt that they were quite, given the distance of separation, being off bedrooms and then having planting right against the wall is something you would typically avoid. So we didn't think 2B was necessary nor reasonable. D was the next one. C is satisfactory. D is actually quite imposing, and that it requires a privacy screen right outside your outlook. What it more or less does to those units is cuts down the outlook in an area where you've got such a separation distance and landscaping. That was also felt to be unreasonable. The blades on the sides will do the job, in our opinion, to the property of Brook Street and also to the western neighbouring property. But the ones to the back are just considered to be excessive and unwarranted. We're not sure about why to F was required. You'll note, sorry, in E and F, you'll notice the screen dimensions. Those privacy screens are 30 millimetres spaced. That's, you know, very fine, so it's virtually a full enclosure. So we take issue with E and F, and those dimensions are well you know, beyond a typical privacy screen. And again, given the distances, separation, etc., and the setbacks are more than compliant, we would say they also are unwarranted. The communal area to the west of the walkway is on the same tile as the subject site, yet the condition also seeks to enclose that screen. So if you're aware of that, the floor plan layout, there's a walkway along the western side of the front building, and what that condition is more or less is doing is screening off that entire western facade to the aspect towards that communal landscaping. So that again is seen to be unwarranted.
Clarify, which one are you talking about now? The condition
2D. 2D,
D.
where it says a privacy screen of 1.6, so it's
Yes.
at eye line,
Yeah.
measured above the finished floor level, shall be provided on the eastern and western sides of the balconies for both the northern portion of the building. So if you were to see that western elevation of the front building, it's actually looking at the communal open space area. So the distance of separation to the western neighbour across the communal open space area is, you know, is extreme. It's like 15 to 20 metres.
Yes.
I'll just check if I can.
The comments on the conditions?
No, that's it, thank you.
That's it. So in relation to the condition, was it D, about the southern elevation shouldn't be screened with a 1.6 metre screen, high screen, would the concern be addressed if it was a planter box?
It could, as long as it didn't have to extend all the way to the glass line or building line. And just going to those. So starting at the first floor, there is one already off the 2 bedrooms off GO4. Sorry, just starting on D8 2002.
No, I was just in terms of just the private open space that's off, looking for the unit number. Yeah, GO3 and 103.
Yeah, so there's a screen on the east side of those, as you can see.
Yeah.
So it is much more or less just focused south to the landscaped area. And as you can see, the separation distances.
But as I
10
understand, the
metres.
conditions requiring that a screen also be put on the southern edge of that balcony. Is
Yes, that's correct. So what
yeah,
that would
and
more
that's
or
what
less
you've
do-
got the concern about.
Yeah, they're 30 millimetre gaps. So anyone sitting or standing would be faced with more or less a opaque screen, or very much a solid screen.
Yeah, so you had a concern about the 30
Correct.
millimetre gaps. They should be wider,
Well,
or you think that, or that the screen itself should go all
correct.
together.
Yes.
The latter.
Yes.
So if the screen were to go all together, could a planter box sort of be put in there, similar to, perhaps not as wide as the one to the north, but
I suppose
to
you have
the-
to say a 600 mil wide planter. That would be sufficient.
Mm-hmm.
That would then not diminish the private open space area. It would still maintain its compliant dimension and area, but slightly above that required.
And in terms of the distance between the any screening where it's 30 millimetres, what is your suggestion in other locations that would be the appropriate distance?
I think, yeah, I'll just speak to the architect if that's okay. Yeah, 100 mils. Oh yeah, so so we've already got some louvers on the sides. Thank you. It's 100 millimetre spacings. That'll allow for light ventilation whilst also providing some privacy.
All right. Did you have any further questions? So in relation to some of the other information that was requested in the deferral was about the actual retention of the existing building. And as I understand it, there's been further work done that now says that you can keep the facade, some of the facades, but all the internal goes, the slabs and the walls. And there's conditions requiring that it be the structural adequacy of those walls that are to be retained be certified to show that they can be kept essentially and that they can support the additional structure. So those are proposed to be operative conditions.
Yes, condition 6.
Yeah, and there's two other ones. I think it's 26 and 27.
Correct.
But because to some extent the design of this proposal is premised on that element of the building being retained, I think if the panel were to approve this application, it would be looking more at imposing that as those conditions as a deferred commencement condition,
Right,
because
understood.
if they couldn't be retained, then you'd have to rethink the whole proposal.
Yeah.
And similarly, in terms of the draft conditions, there's conditions 18 and 19 that relate to drainage and flooding. And again, they're operative conditions, but 18 in particular requires that you provide a detailed analysis of the existing flow path regime and flood levels, which to some extent there's a bit of uncertainty as to what that information would provide. So potentially that would be better as a deferred commencement condition if we were to have a mind to approve the application.
Yeah, I was on the understanding that council's engineers have reviewed the updated information and are satisfied that the pre and post conditions will be better. But I think the condition has just remained in there. But do you mind if I just confer with my client?
Sure.
Quickly? Thank you. That's satisfactory if it's as deferred. Thank you.
All right. I think was all my questions. Thank you.
Thank you very much.
So I think that's all the speakers. So now we've heard from all the speakers in accordance with the panel's guidelines. The public meeting will now be closed and the panel will move to another room to deliberate and vote on the application. The panel will not return to the council chambers today. The outcomes from voting and determination will be made available through council's website either late tonight or tomorrow. An audio recording of the public meeting will also be made available through council's website. I declare the meeting closed at 1:28 p.m. Thank you.